The USDA doesn't break its own contracts. That was true until January 2025, when a single DOGE spreadsheet flagged more than 600 farmer grants for termination, freezing over $6 billion overnight. Farmers who had already hired staff, ordered equipment, and launched projects received form letters ending everything. A federal court called the terminations likely illegal. But what the government argued in its own defense may be even more alarming than the act itself. In the last week of January 2025, the Department of Agriculture, steered by the newly minted Department of Government Efficiency, triggered a wave of cancellations that stunned the farm sector. A total of 617 USDA grants and contracts spanning every region from the cornfields of Iowa to the orchards of Oregon were terminated or frozen in a single sweep. The numbers defy belief. More than $6.3 billion in obligated federal funding, wiped from the ledgers overnight. The impact was immediate and sprawling. Tree planting initiatives, climate-smart agriculture pilots, local food networks, and beginning farmer training programs all went dark. In the Midwest alone, nearly 4 out of every 10 affected projects were in Illinois, Iowa, and Ohio. The Southeast lost more than a quarter of its active grants, while the Pacific Northwest and Great Plains saw millions in planned investments vanish. For hundreds of farmers and nonprofit leaders, the timing could not have been worse. Many had already signed contracts, hired crews, and placed orders for seed and equipment. Payrolls had been set, training cohorts assembled, and community partners lined up. Projects that took years to plan unraveled in a matter of hours. The government's own spreadsheet, later published by watchdogs, listed each grant by ID amount and a terse note: terminate for convenience. Department of Government Efficiency. No warning, no negotiation. Just a mass email and a digital ledger of losses. This was not a bureaucratic shuffle. It was a national rupture, felt in every county where a grant had promised jobs, training, or a new harvest. The numbers alone reveal the scale, but the real story is what those numbers meant for the people and communities left behind. Inside the Department of Agriculture, the contract purge began not with debate, but with a spreadsheet. The Department of Government Efficiency, DOGE, assembled a digital list that would decide the fate of more than 600 grants and contracts. Each row carried a project ID, funding amount, and a single phrase: terminate for convenience, DOGE. This administrative tool froze or canceled $6 billion in federal support, cutting across tree planting, climate-smart partnerships, local food procurement, and beginning farmer training. The process was as stark as the numbers. DOGE analysts applied a keyword filter to every grant application, flagging any that mentioned terms like diversity, climate modeling, or underserved communities. 24 words in all, each one a potential red flag. If a project's budget surpassed $5 million, it was automatically added to the termination list. Legal memos from USDA's own contracting officers warned that this approach violated federal law, but their objections were overruled by the Secretary of Agriculture, Tom Rollins. The final termination authorization form, signed January 21st, 2025, bore the signatures of Deputy Undersecretary Maria L. Torres and DOGE Director Kevin M. Patel. On January 24th, 2025, a mass email went out. Attached was Form D, a standardized letter citing the convenience of the government as the reason for cancellation. There was no negotiation, no case-by-case review. 4 regional food business centers, planned for Alabama, Kansas, New Mexico, and Virginia, were terminated before a single dollar had been disbursed. Internal memos show these projects were cut at the pre-award stage, their economic impact erased from USDA's own forecasts. The spreadsheet, updated weekly, became the official record of loss, a bureaucratic filter applied in bulk that turned policy preference into a ledger of broken commitments. Kitchen Sink, a nonprofit food systems group in central Illinois, became a symbol of the human cost behind the government spreadsheet. Their $400,000 USDA grant, meant to support a network of 1,000 small vegetable growers, vanished with a single email. The organization's director, Megan Hayes, faced a payroll shortfall overnight. Within 48 hours, Kitchen Sink issued layoff notices to 25 staff members, a cut that slashed $112,000 from their payroll. For the employees, many of whom had moved or taken on new childcare costs based on the promise of year-long work, the news came without warning. Vendors felt the shock as well. Greenfields Company, a regional seed supplier, saw a $68,000 contract for heirloom seeds voided. Their invoices stamped void in red became part of the litigation record. Northwest Nursery, slated to deliver 150,000 tree seedlings for a climate-smart forestry project, canceled its order after the USDA termination notice. The loss of that single contract left $845,000 in sunk costs and wiped out the season's planting plans. Kitchen Sink's leadership tried to hold the line, dipping into personal savings to cover $22,000 in pending payroll. But the numbers were impossible to bridge. The organization's training programs halted mid-cohort. Stipends for new farmer apprenticeships were suspended, and community partners reported empty greenhouses and idle packing lines. In court exhibits, these losses were documented through payroll registers, vendor cancellations, and personal bank statements. They formed the backbone of the legal case that would soon challenge the government's authority to erase contracts by executive fiat. For the farmers and staff, the damage was immediate and deeply personal. Numbers on a spreadsheet translated into lost livelihoods and broken trust. On June 5, 2025, 6 farmer-led organizations filed suit in federal court, demanding accountability for the government's actions. The coalition, led by Earth Justice, the Farmers Justice Center, and Farm Stand, brought together groups representing food hubs, beginning farmer programs, and climate-smart collectives from across the country. Their complaint, lodged in the U.S. District Court for the District of Columbia, laid out a clear argument. The USDA had violated the Federal Acquisition Regulation, the Administrative Procedure Act, and the very terms of congressional appropriations by terminating over 600 contracts and grants without cause. The legal filings drew directly from the government's own records. Attached to the complaint was the now infamous DOGE spreadsheet, a digital roster of 617 terminated grants, each flagged with a terse note that said, "Terminate for convenience, DOGE." The plaintiffs argued that these mass cancellations were not only arbitrary, but also illegal. The lawsuit cited internal USDA memos and contracting officer objections, evidence that the agency had ignored warnings about statutory violations. Counsel for the farmer groups, including Annika Patel of Earth Justice and lead attorneys from Farm Stand, focused on 3 central claims: that the USDA's blanket terminations lacked any reasonable basis as required by the Federal Acquisition Regulation, that the agency failed to provide a reasoned explanation as mandated by the Administrative Procedure Act, and that the actions amounted to a breach of due process under the Fifth Amendment. Hundreds of pages of exhibits documented the fallout: payroll records, vendor cancellations, and personal statements from affected farmers. The complaint named the specific programs at risk: tree planting initiatives, climate-smart agriculture pilots, local food systems, and training grants for new farmers. The plaintiffs described a pattern of selective targeting, with grants mentioning terms like diversity or climate modeling disproportionately flagged for cancellation. The legal team made clear that this was not just a policy disagreement, but a wholesale breach of contract and a violation of the rule of law. With the case now before a federal judge, the fight for reinstatement, and for the principle that executive power has limits entered the courtroom. On August 3rd, 2025, the United States District Court for the District of Columbia issued a preliminary injunction that sent shockwaves through the farm policy world. Judge Miriam K. O'Malley's order called the United States Department of Agriculture's mass grant terminations likely illegal, rejecting the agency's sweeping rationale as insufficient under federal law. The court's language was unflinching, saying the government's actions would cause irremediable harm if not immediately halted. 6 grants, including Kitchen Sink's $400,000 contract and the Midwest Tree Planting Project, were ordered reinstated pending a full trial. For hundreds of rural communities, the ruling was more than a legal technicality. It was the first real acknowledgement that the government's abrupt cancellations had crossed a line. The agency's vulnerability was now publicly confirmed, and the promise of justice, at least in part, was restored. USDA officials defended the mass terminations by invoking executive authority, insisting that the president's policy agenda allowed for swift, sweeping action. Their legal filings leaned on the idea that contracts could be ended at the administration's discretion, a claim that critics quickly labeled government by presidential whim. But contract law scholars saw a clear breach. Professor Ellen H. Carter of Georgetown Law explained in national op-eds that federal grant agreements are not blank checks for executive preference. They are binding commitments, enforceable by law. She called the USDA's defense a misreading of contract doctrine, noting that blanket political directives cannot substitute for the formal, documented reasons required under federal procurement rules. Internal DOJ memos, submitted as court exhibits, echoed this skepticism, finding the agency's rationale insufficient and warning that the government risked liability for breach of contract. As the legal arguments unraveled, the USDA shifted quickly to a new strategy, recasting the episode as a fight for farmer freedom, hoping to blunt the impact of the court's sharp rebuke. On February 11th, 2026, Secretary Rollins stood beside country singer John Rich to launch the Farmer and Rancher Freedom Framework, recasting the mass contract terminations as a defense against government weaponization. Yet, hundreds of grants remain canceled, their losses still tallied as savings on USDA dashboards. For affected farmers, the fight is not over. Each has just 30 days to file an appeal with the National Appeals Division, often with little legal help and no clear roadmap for recovering what was lost. Today, hundreds of canceled contracts and over $6 billion in frozen commitments remain unresolved. The court called USDA's actions likely illegal and warned of irremediable harm. Rule of law hangs in the balance. If contracts can be broken by spreadsheet, no farmer's future is secure.